I'm going to read this declaration. It's in the case of Laura Lynn Hammett, that's me, versus Portfolio Recovery Associates, LLC. Hammett's declaration in support of motion to strike comments from order of recusal. I, Laura Lynn Hammett, am the self-represented plaintiff in the above captioned case. I'm over 21 years old, competent to testify, and if called to do so, would testify to the following facts under penalty of perjury. The facts are within my own personal knowledge. I have written a blog titled A Higher Law since about 2008. From 2015 to about 2019, I took a sabbatical on the advice of my therapist because some of the most powerful government employees in the nation, judicial officers, took vengeance on me for writing things they did not like. Withstanding their speech-chilling conduct was stressful. One example is Commissioner Alan H. Friedenthal, now deceased. He presided over my family law case, LLVTL. He said he read my blog in open court and expressed disagreement with some of my opinions and clearly labeled suspicions and misstated my allegations. Now I go to a footnote that says this was during a hearing in which I was not provided assistance of counsel, and that resulted in my parental rights and my children's right to contact with their mother being completely severed. The order was reversed as to one child through a juvenile court a year later, but the other child and I had no contact for 5 years. Fox News featured my blog and Commissioner Friedenthal in a series about imbalanced justice. End of the footnote. This resulted in a severe public admonishment. That was my husband popping his head up. This resulted in a severe public admonishment, even though the Commission on Judicial Performance seemingly adopted Mr. Friedenthal's misstatements about what was written. I attached a copy of that. On January 7th, 2025, I posted a piece entitled Portfolio Recovery Associates Continues to torment consumer years after closing the account on the blog. And I put a copy of that as an exhibit. I explained in the piece that the motion to unseal the documents in question at the Supreme Court, served on October 24, 2024, was titled on the docket as if it only asked to file the sealed documents, but omitting the bulk of the 10-page motion argued for unsealing. Quote, motion granted, unquote, meant to me that my motion to unseal was granted. My belief that motion granted meant the entire motion is based on a fact that can be accepted by judicial notice, that judges uniformly distinguish a motion that is granted in part and denied in part when only a portion of the motion is granted. While writing this declaration on January 15, 2025 at about 8:51 a.m., Superior Court case analyst Angela Jimenez called me. She said she's sending a certified copy of the motion to seal and unseal to me. She explained that the file date is not always the date the document was served. For example, when a notice to correct deficiencies within 60 days is issued, the date the corrected document is mailed does not become the file date. In case 24-6113, my case, my motion to seal and unseal was sent without notice to correct. Ms. Jimenez and I discussed the deficiency around the time I mailed the petition for writ of certiorari and she said I could combine the motion to seal with the motion to unseal, and she would hold the petition for docketing. The file date and the docketing dates are different. She said that motions to unseal are titled motions to seal on the docket. I did not hear any reason given why the Supreme Court justices did not write denied in part. Portfolio Recovery Associates attorney James Treffel's certified statement that I did not serve the motion that the Supreme Court calls motion to seal was a falsehood. I served it on him with tracking on October 24, 2024. PRA chose not to oppose that motion. It appeared to me that Judge Rudofsky's bias existed before December 20th, 2024, when he ordered me to work through Crispus and did not sanction PRA for committing fraud on the court after the emergency motion was briefed. I received no communication from Judge Rudofsky that put me on notice that he intended to read my blog. I was given no opportunity to provide copies of the blog posts or argue there were no posts relevant to the motion other than the ones I filed in RDoc 304. There were others, but I would argue that they are repetitive and prejudicial. It might reasonably appear to a reasonable person that reading the blog would cause a bias and would not illuminate the issue of whether I should be sanctioned for publicizing the 4 documents and then not knowing they had to be removed from my media library to make the URL invalid. On January 6th, that was a mouthful. On January 6th, 2025, I published a piece titled, Judge Rudofsky gives pro se 5 days for emergency response. Billion-dollar firm gets 10 to reply on my blog. Oh, I've got to correct the quotation marks. Not a big deal. The piece described what appears to me to be a bias against individuals in favoring big business billionaires. And I put a copy as an exhibit. I described PRA's fraud. PRA claimed the motion for sanctions was an emergency. I cited the email dated December 21st, 2024, from WordPress parent Automatic's attorney. PRA filed on January 6, 2025. So they waited 2 weeks. PRA did not previously share this email with me or discuss its contents with me, despite Automatic delegating that responsibility to PRA. Had PRA told me about Automatic WordPress's offer to help me discover how to break the link to the documents in question, I would have contacted support immediately. I did not contact WordPress independently because I mistakenly thought that deleting the links on the post discontinued hosting by WordPress. I found out about my media library and how to delete documents from it by asking ChatGPT. This was before I read the email in PRA's exhibit. Oh, I'm going to have to add something. PRA actually suggested to me that and they did it in their motion that the documents might be in a Google account. So they're the ones who threw me off. I found out about my media library and how to delete documents from it by asking ChatGPT. This was before I read the email in PRA's exhibit. A few days ago, I met a woman at the Root Cafe. We decided to share a table. She is a veteran of Iraq, who specialized in electronic security. She works now protecting electronic security for a bank. I explained the situation that I deleted the links on my blog, but the documents were still accessible to those with the original URL, and asked why that was happening. She did not know. When I told her the answer, she immediately recognized that my solution would work, but said different platforms work differently, so the solution is platform specific. I was not slacking in finding a cure, especially since I had to write and file my response in a shortened period and had other responsibilities and issues. Giving me a severely shortened time to respond to serious accusations with serious consequences, denial of my First Amendment rights, gives Judge Rudofsky the appearance of bias. Reading my blog would also be prejudicial, but it appears to me that Judge Rudofsky used that unethical conduct as a red herring to deflect from the former problem. Pursuant to 28 U.S.C. Section 1746, I declare under penalty of perjury, under the laws of the United States, that the foregoing statements are true and correct to the best of my personal knowledge. So, thanks for listening. If you have any comments, post them below. Like and subscribe. Let's get this blog going, this vlog going, now that PRA and Judge Rudofsky and Judge Brian S. Miller have successfully taken down the blog www.court-corruption.com. If this is passed, I think the 17th is when we're having our hearing. You'll be able to find out if the blog has been renewed. But in the meantime, visit this vlog. Thanks.